All right, today we are jumping into a really fascinating and, let's be honest, pretty controversial theory of law that's been making the rounds online. The idea here is to completely flip how we think about the legal system. It suggests that it's not about facts or justice, but about the specific words written on a piece of paper. So let's unpack this. Imagine for a second that the whole legal system is just a game. And what if the rules we all think we're playing by aren't the real rules at all? That's the core question this whole theory is built on, that there's another game happening right under our noses. And this slide right here gets straight to the point. Most of us think of courts as places for justice, right? You argue facts, you apply the law. But this other view, it claims courts are actually just about enforcing commercial contracts. That one simple shift in perspective, well, it changes absolutely everything. So let's start with that first big idea. This notion that courts are basically just a business arena. According to this theory, it doesn't matter if it's a civil case or a criminal one. At the end of the day, it's being treated as a business deal. The argument is that they're not really halls of justice searching for truth. Nope, they're commercial enterprises looking to enforce a contract, sometimes one you didn't even know you agreed to. Now, to really get how this is all supposed to work, you have to understand this key distinction the theory makes. The difference between who you actually are and who the court thinks you are. And that brings us to this concept of a legal fiction. The idea is that the state creates this corporate version of you, a separate legal player in the game that just happens to have your name. And the biggest clue, they say, when you see your name written in all capital letters. And they claim this isn't some obscure thing. It's hiding in plain sight. I mean, think about it. Your driver's license, tax forms, a court summons, even your birth certificate. The theory is that all this official paperwork isn't talking to you, the person, it's talking to your legal fiction. This chart really lays it out. You've got the living, breathing person on one side who operates under a simple principle. Just don't harm anyone. That's common law. But then you've got the legal fiction, this corporate player, who operates under commercial law. And the alleged trick of the whole system is to get you, the person, to show up and agree to act as the legal fiction, which means you've just agreed to play by their commercial rules. Okay, so if this whole thing is a game of commercial contracts, then you've got to know the rules, right? The theory says you first have to understand what makes a contract legitimate in the first place. So this theory lays out some pretty basic rules. For instance, both parties have to be of the same kind. You can't have a living person making a contract with a fictional company, apparently. There has to be full disclosure, a fair exchange of value, and both sides have to genuinely agree on what they're agreeing to. The central claim here is that almost all official documents you get, they fail on one or more of these points. And this is really the linchpin of the whole idea. If you can prove that there was no valid, binding contract based on their own rules, then their entire claim to have any authority over you just evaporates. No contract, no case. So how do you actually do that? How do you put this into practice? Well, the next step involves hunting for something the source calls language fraud. Now, this is a huge mental shift. The argument is that the courtroom, the judge, all of that, it's not the real battleground. The actual court is the piece of paper they sent you. The entire fight happens within the four corners of the document. And how do you win on that battlefield? You become a detective. You look for these so-called defects. We're talking about things that most of us would just ignore, a word in brackets, mixing will happen with did happen in the same sentence, even weird little word plays. The claim is these aren't typos, they're intentional errors that make the contract void. Here's a perfect example of what they mean. Look at this sentence. See how tenant is in brackets and the date on the first is in parentheses? And then it mixes future tense, shall pay, with past tense, was due. According to this theory, each one of those is a defect that technically breaks the contract. All right, so you found these supposed defects in the document. What do you do now? This leads to the core strategy, which is called asking for correction. The idea here is instead of arguing about the facts, I didn't do it, you just politely point out the problems in their paperwork. You're not fighting them. You're just asking questions. Hey, I'm a little confused by this word in brackets. Could you please clarify what it means for me? It's a totally different approach. And the goal is actually pretty clever. You're shifting the burden of proof. It's no longer on you to prove you're innocent. It's on them to prove that their paperwork is even a valid contract in the first place. And if they can't explain their own terms, the theory says their whole case just falls apart. Now, we have to stop here for a second because this is a really, really important disclaimer from the source material itself. This entire strategy is supposedly for contractual or administrative issues. It very clearly states if you actually caused harm to another person, a lot of these rules go out the window. That's a different ballgame entirely. So, what's the big takeaway from all this? This theory is all about a massive shift in strategy. It's about stop playing their game of arguing the facts and start questioning the very game board itself, the legal documents that give the system its power. And that kind of leaves us with a final thought. Now, it's super important to remember this is a highly unconventional theory, and it's definitely not legal advice. But whether you buy into it or not, it does make you ask a pretty interesting question. If the grammar and punctuation in a document could hold so much alleged power, doesn't that change how you look at every single contract you sign from now on?